So welcome everybody. My name is Carolyn Abbott and I'm currently the head of the law department, and I'd like to welcome you all to Manchester and to the 2025 Melland Schill Lecture. So this year the event takes a special roundtable format featuring 3 leading scholars in international law. So on that note, I'd like to extend a very special welcome and thank you to our distinguished speakers, Professor George Galindo from the University of Brasília and Simon Visiting Professor, Professor Nehal Bhuta from the University of Edinburgh, and Dr. Megan Donaldson from University College London. Now, this lecture series exists thanks to the bequest of Olive Schill, who was the sister of Edward Melland Schill, who died in 1916 during the First World War. And the income from this bequest supported the creation of a public law series devoted to international law, and it's recently been revived under the auspices of the Manchester International Law Centre. So without Olive's generosity, the series wouldn't exist today. Now, of course, these events don't get plucked out of thin air. They take considerable thought and planning. And on that, I'd like to thank Justina and Emma for all their hard work in making this roundtable happen, and our lovely final year undergraduate student for making sure that everyone sits in the right place. So without further delay, I'm going to hand over to Justina. Hope you enjoy the event. Thank you very much.
Okay, we're all good. Good evening, everyone. My name is Justina Uriburu, and I'm a lecturer in international law and one of the co-directors of the Manchester International Law Centre. It is a great pleasure to welcome you all to the 2025 edition of the Melland Schill Lecture Series. So before we begin, I would also like to thank those who made the event possible. Emma Nayan, my wonderful co-director. Eleanor, once again, thank you. And thank you also to our colleagues of the Manchester International Law Centre and the Law Department for supporting this event. So as many of you know, the Melland Schill Lecture Series is one of the flagship events of our centre, and it reflects the long-standing tradition of international law at the University of Manchester. And since its revival in 2014, the Melland Schill Lecture Series has sought to critically engage with urgent problems in international law, past, present, and future. And what counts as an urgent problem today? So one might say nearly everything. It is hard not to notice that traditional hubs of international diplomacy, such as Geneva, are losing influence. Long-standing political alliances are fracturing. Governments increasingly rely on security and emergency measures to withhold information. And artificial intelligence is making decisions with minimal human oversight in critical areas such as war, climate change, and migration. And public debate, too, is permeated by this sense of uncertainty. Even The Guardian recently asked whether we might be witnessing the death of international law. But we do not want to reduce the discussion to that headline, nor to be swept up in narratives of crisis that can easily lead to simplistic analysis. Instead, we want to understand what transformations are taking place, what they mean for international law and for our understanding of the history of the discipline, whether international law as a discipline and as a language can adequately capture these transformations, and what the present moment ultimately demands of us as academics. So we're fortunate to have an exceptional panel of scholars to guide us. I will introduce them by mentioning their current positions. So we will first hear from Megan Donaldson, Associate Professor at University College London. We will then hear from George Galindo, who occupies not one, but many positions. He is a professor at the University of Brasília. He's legal advisor to the Brazilian Ministry of Foreign Affairs. He serves at the UN International Law Commission and at the OAS Inter-American Juridical Committee. And he's also Simon Visiting Professor at the University of Manchester. And finally, we will hear from Nehal Bhuta, who is Chair of Public International Law at the University of Edinburgh and co-director of the Edinburgh Centre for International and Global Law. So each speaker will speak for about 15-20 minutes, and then we will have 30 minutes for questions. So thank you, Megan, Nehal, and George for being here. Megan, the floor is yours.
Thank you. So thank you, Justina, and thank you to everybody else who's helped make this happen. And it's a real pleasure to be here tonight with colleagues and with you. And I do think that in this time of dislocation and perhaps disintegration, there's something fitting in having three voices drawing distinct cross-sections through this domain that we call governance. Indeed, one thing which might be in play between us is this question of what we mean by governance and what are the stakes of thinking in terms of governance as opposed to law. I'm going to take as my way into this question of who or what governs the role of publicity, which we sometimes call transparency, and its relation to law. I take up these two threads because both have been central to how we imagine governance or order beyond the state through at least the 20th century to the present. And one could also make the case for the 18th century. The purpose tonight is not to be kind of encyclopedic, but just to give us some things to think with from our recent past. I take these threads, publicity or transparency and law, together as twinned technologies of governance. I think they're closely related, but they're not the same. They're sometimes been seen as part of one holistic vision and sometimes understood as alternatives in some respects. And they are sometimes in reality resistant to each other in ways we haven't always noticed. I'm going to pursue these threads broadly historically, drawing on a very long-standing project. I want to start in the early 20th century, which is itself a time of cacophony and rupture when mass politics were bursting the containers of states and empires, and advances in technology were nurturing deep fears about the nature of war to come. In these circumstances, before and immediately after World War I, publicity and international law offered two somewhat distinct ways of coming at the question of who or what would govern the form of the future world, checking, amongst other things, the dynamics of competitive armament and the febrile nature of diplomacy. However, one of the things that's falling apart today, I think, is the dominant sense of the history of the international system. So I'm as much unpicking dominant narratives tonight as I am trying to assert a new one. After sketching the constellation of thinking about publicity and law after World War I, or immediately before and after World War I, I'll then sketch and complicate one dominant history of publicity or transparency and law over the 20th and 21st century. And then I'll say something which is a bit more speculative and tentative about the here and now, sketching what I think is a dominant critical account of transparency and law and how we might need to complicate that in turn. So the hope is that rethinking how these technologies of governance, transparency, law have worked and how we have plotted these historically helps us with the task of thinking anew about the past and about the future. So let me begin at the tail end of what we often call the long 19th century, like really the first years of the 20th century. This is a period in which most of those who are closest to government and administration didn't see law necessarily as the dominant mode of interaction in the international system, and they didn't see it as hermetically sealed off either. The most obvious efforts to assert law over force in the form of commitments to arbitrate disputes retained very broad self-judging exceptions. And even treaty making in general, which we as lawyers today tend to think of as paradigmatically a legal technique, was seen by those making treaties as a matter of honour and interest as much as legal commitment specifically. Honour and interest being, among other loose vocabularies of rule, which worked alongside things like demography, economic might, military and naval power to shape the world. So law in this period was understood, I think, paradigmatically through this treaty form, and it was largely public, but with a systemically very important possibility of secrecy. International law didn't require that treaties be published. It didn't prescribe a particular form of treaties. It left open a space for the diplomatic craft of drafting, which embraced layered public and secret texts. Nor did the constitutional law, even of most liberal polities, require disclosure of treaties to the legislature or public in all circumstances. And this pattern of secrecy in treaty making played a crucial role in two major structures of governance, in networks of alliances and in the mechanisms of informal empire. In each case, secrecy wasn't absolute. It wasn't absolutely about suppression of information, but rather filleting the information which would be given to different audiences, maintaining ambiguity or uncertainty on certain crucial points. In the case of alliances, about what exactly had been promised in what circumstances and what would trigger the realization of that commitment. In the case of informal empire, secrecy was what made the informality possible. So it holds together de jure sovereignty of a nominally independent polity with de facto subordination, a high degree of external control over the economy or foreign policy of this nominally independent polity by other powers or by corporate interests which are in some way enmeshed with other states. And in informal empire, the secret treaties tended to be among the powers who were competing for informal control, stipulating which of them would have which rights and interests if the independence of this nominally sovereign polity should happen to falter. Treaty making in these domains under conditions of secrecy valorized the peculiar importance of legal commitment. So the fact that states bothered to make a thing which they understood as a treaty, even though it possibly wouldn't be made public and would never be vindicated in any adjudicative context, suggests something. There was an importance attached to law. Secrecy was accommodated by law, but the resulting commitments were sometimes so contradictory that they hollowed out the power of law as a meaningful instrument of governance. And the result was perceived by many at the time as profoundly unstable, creating conditions in which individual statements of heads of state or foreign ministers, a few words here or there, broadcast through the press, might constitute a casus belli. We tend to focus in a kind of liberal historiography on Woodrow Wilson's wartime calls for open covenants, openly arrived at as the definitive turn against this system. But in fact, this is a bit of a distraction. American audiences were always very incurious, right, about what their government was doing, particularly in Latin America. They saw secret diplomacy as a pathology of the old world rather than of their own. And it was in Britain and France before World War I that there was most public debate and reflection on constitutional reform, incidentally here in Manchester, through the Manchester Guardian, great liberal paper. So it was tensions between France and Germany over rights in Morocco, the exact exemplification of this informal empire, which put pressure on a whole interlaced series of secret treaties between other states, causing some of them to leak and then further layers of secrecy to be built into the patch-up. In France, these arrangements felt very reminiscent of the secret du roi, an absolutist form of rule at the core of a nominally republican order, and in Britain they connected into very long-standing arguments about the anachronism of the prerogative. But in both of these states, even the legislators and the activists who pressed for new constraints on secrecy encountered difficulties in pinning down what would be made public and to whom. Would treaties be disclosed only to legislative committees or specialist representative oversight of some other form, or was it to the citizenry at large? And did the dynamics of the modern press, to whom these things would be disclosed, make disclosure a pacifying force or exactly the opposite? All these questions come to a head again, obviously, in World War I, after the Bolsheviks seized power in 1917 and find in the Tsarist archives all these fairly invidious secret treaties which had been made in the course of World War I and beforehand, and release them. At that point, the condemnation of secrecy has a kind of inexorable appeal, but it's so strong and so much of a stark morality play that it circumvents some of these more difficult questions which had already been ventilated in the pre-war debates. At this time, publicity of treaty making and of diplomacy more generally was presented as pivotal. It's a means of transforming politics between and within states. Though it's connected, it's worth remembering, to radically different visions of politics. So the Bolsheviks are envisaging existing states and empires essentially falling away. Peace is going to be ratified by authoritative assemblies of the people's representatives of all countries and nations, to quote the Decree on Peace. The British variant of new modes of diplomacy essentially continues the pre-war preoccupation with empowerment of the legislature, the metropolitan legislature, we stress, within empire, and thus distantly amplifying the power of electoral publics against the executive. Wilson's formulation of diplomacy in the public view very characteristically lacks any institutional specificity or any notion of representation, actually. It's simply transposing an idea of the public from a conventionally national frame to a global scale, and it's the publicity in a way that makes the public for him. In myriad different ways, this valorization of publicity as a technique of governance is written into the international legal order through the Covenant of the League of Nations and through some of the early decisions made in that institution. So you have the requirement to register treaties, You have publicity built into different stages of the League Council's consideration of disputes. You have an expectation of public disclosure of statistics on armaments as a key intervention in the build-up of armaments. You have a turn to publicity of proceedings in the new PCIJ as the decisive break from diplomatic modes of arbitration. Now, many accounts of the development of transparency in international law connect this 1919 moment more or less seamlessly to the fall of the Soviet Union. So it's one great progression, right, in which publicity and law and liberalism and peace all go together. Most of these accounts do note that you have the growth of a security state after 1945, which comes together with the growth of collaborative security and secrecy regimes. But they do see this as just one footnote to a broadly optimistic arc. And even the more conceptual accounts, and those by Sandrine Bohm and others, similarly draw a pretty straight line from Kant and Rousseau and Bentham to the transparency of the 1990s. It's all a similar program. Really excavating what occurred here, in fact, shows a very different picture. And let me just briefly highlight 5 dimensions which emerge when one looks more closely. First, a tapestry of immensely complex experimentation with publicity as a technique of governance. So in multiple different facets of the League of Nations, we see encounters, difficult encounters between the ideal of publicity and an envisaged global public and the reality of how you reach uneven, conflicting global publics. And although publicity regimes are nominally premised on views of where power lies, experimentation brings frustration, right? So to take the armaments context, very hard-fought regimes for collation and publication of statistics don't deliver the levers of power that the very substantial, influential disarmament movement expect. And activists turn to amateur investigation of armaments firms, which they think is where the power lies, and their global interconnections. And they force legislative inquiries domestically when they get nowhere at the League. So publicity turns out to be much more complex, much more varied, but also protean. So it's not a set institutional solution. It's a repertoire of techniques and practices that different activists take up. Second, the development of publicity is accompanied in many contexts by a tacit preservation of secrecy. And it's not a preservation of secrecy by those who are defenders of the old order. It's often by those at the vanguard of what we would call liberal internationalism, or the construction of the new international organizations, trying to get new modes of cooperation off the ground. Again, this secrecy isn't oppositional to law all the time. It's made possible by law, accommodated within international law. And in fact, the legalization of debate about some of these things, and secret treaties as a prime example, makes the situation more opaque to the mass publics, which were intended to be engaged by this. Let me just give one key example, again in the armaments context, of the kind of dynamic relationship between the call to publicity and the generation of new modes of secrecy. Basically, the covenant envisaged that states would publish armament statistics, and that this would be a way of engaging democratic publics in the control of armament programs. But in fact, the call to publish statistics prompts governments to articulate military secrecy with a precision that they had never done before. They had a loose understanding of secrecy, but they had never kind of crystallized it. And so you have a dynamic relationship in which the call for publicity evokes a kind of counter-response. Publicity and law in all these regimes are developing together, but in ways which are sometimes mutually reinforcing, sometimes mutually resistant. Developments in the Cold War and decolonization, thirdly, very belatedly prompt scrutiny of the material infrastructures of knowledge circulation, which underpin faith in publicity. So after World War II, you have deep conflicts over what was then called freedom of information that are examined inter alia by Wan Shu Kong at ANU. But what was at stake in these is not what we mean by FOI today, but a set of arguments about the arrangements for global media that are deeply contested by the Soviet bloc and the Third World, concerned about unequal power in shaping international flows of information and understanding. And that has echoes today. Different rules, different forms of media technology, but similar concerns. When we come fourthly to the 1990s, when transparency was newly injected with the meaning that we still understand it to have today, it wasn't a simple or unitary idea. It probably achieved the ubiquity that it did, in part because it resonated with so many different projects. So a distinctive body of thought and jurisprudence on right to know in post-authoritarian Latin America, glasnost or openness in the post-Soviet sphere. It resonates with neoliberal emphasis on paring back and exposing the workings of government to liberate the market. But it's also about an embrace of what John Keane called monitory democracy, an acceptance, celebration indeed, of the administrative state and the development of new sites of post-parliamentary democracy to match it. And while transparency came to be associated with particular statutory and institutional regimes for disclosure, propagated and refined and improved by international organizations and NGOs, that word itself as a political program travels and transmutes. So Aradhana Sharma has traced the plasticity of what she calls a techno-moral politics, the way in India demands for transparency evolved from initially quite bottom-up interventions against corruption, built towards the Indian right to information law, but have now been taken up and evolved in more populist movements which have themselves turned towards quite authoritarian politics. And we find this similar plasticity in other contexts where transparency is evoked as a political project. And finally, while publicity, or at least the push against secrecy in the early 20th century, was connected to empowerment of peoples or electorates, radical or at least minimally democratic notion of representation, transparency is more commonly now, I think, invoked in the governance context as a palliative to a loss of national democracy. It's at best a workaround or a substitute for modes of governance beyond the state. In this sense, it can reinforce law as a mode of governance because it evokes these procedural values which are quite deeply entrenched in the public law of individual states. And it's been taken up and celebrated and forged into what some call a new global administrative law, which is imagined as a way of constraining the exercise of power not only by states, but by all these international organizations, private and hybrid entities. At the outermost limit, this could function as a sort of apparatus of deliberative democracy, improvised. But we also see transparency evoked as part of the deformalization of governance. It's a vocabulary which legitimizes shifts from formal intergovernmental organizations or treaties to more fluid and transient coalitions, partnerships, projects. So looking again at this quite complex lineage and the different relationships between publicity, transparency, and law in these different contexts and moments shows us how much is in play between these twin technologies and the politics that they envision and they animate. Let me just say a couple of words about where we are today. So when we appeal to law, I think these appeals are pretty fervent, but also fragile for all the reasons Christina has mentioned. Even if we understand law in quite austere ways, as a sort of minimal language of interstate relations, rather than something thicker and more substantive, it's very precarious. It's challenged not only by flagrant breaches, by non-reaction to the breaches of others, but also by this process of deformalization, prevalence of quantitative indicators by algorithmic governance. Transparency, of course, remains ubiquitous as part of the picture, and it's part of the go-to repertoire of techniques that we call on to resist or control or steer things like the development of algorithmic governance. But we're also seeing a growing distrust and disenchantment with transparency itself as an ideal. So from the political left, figures like Jodi Dean and Claire Birchall are increasingly suspicious of it, and others too in a more aesthetic vein. This is in part driven by changes in technology and their role in democracy. So appeals to transparency can sometimes feel to critics as though they're almost completely merged with neoliberal governance, or that they underwrite some form of all-pervasive surveillance of all, rather than engineering an accountability of elites to those below. I was initially quite attracted to this view, and I'm now less sure about it. So this could be part of a general pattern that we see today in which people who were relatively comfortable in a position of critique now feel the world tilting under them and discover a strange new respect for liberal principles or procedural norms. So that may be a part of the story. But I think at least part of my unease also comes from the historical thinking. I've tried tonight to disrupt the idea that there is some constant notion of publicity or transparency in governance over time, and I don't think there is. But there are family resemblances between these demands for knowledge and practices of revelation. And the way that these persist and shapeshift as regimes of power change tells us something, that some kind of concern with the circuits of knowledge and information, some effort to break these open is going to be a non-negotiable dimension of any intervention in the way that we are governed. So if we widen the aperture to moments before we talked about transparency, we're at least allowing ourselves to wonder if we might be a little bit too enthralled to the metaphor when we get caught up in the critique of transparency. And if transparency was never as totalizing and never had the promise that we associate with the absolute quality of the word, nor is it perhaps the threat it might appear. So we have a choice about how we receive and understand that vocabulary. Transparency politics is always going to be with us, but it might in the future take different names and forms. And we cannot theorize it without engaging with the modes of governance that we are seeking to make visible or legible, many of which will go beyond law as we know it.
Thank you, Megan. George, the floor is yours.
Okay. First of all, thank you very much for the opportunity of being here. I mean, it's quite enriching, this possibility. And this is a quite important topic, not only for international law, but international relations in general. And I would like to focus on a very specific issue regarding diplomatic law and the idea of secrecy, specifically the idea of how diplomatic documents can be treated in the face of this phenomenon, which is an increasing demand for more transparency. And I think one of the bases for any discussion on the diplomatic document and transparency is that, I mean, international lawyers often they consider diplomatic law and the Vienna Convention on Diplomatic Relations as a quite stable underpinning of international law. If you go, for example, to textbooks on international law, many authors say that the Vienna Convention is a true codification of customary international legal rules, or they say that the Vienna Convention on Diplomatic Relations is a universal treaty, and in fact it is, or almost. I think it 193 states, something like this. But at the same time, there is this tension of increasing demands for more transparency. But the Vienna Convention on Diplomatic Relations establishes quite clear points on, for example, on the idea of the inviolability of the diplomatic document. There are no exceptions, as we'll see here. It's unqualified, the protection of the diplomatic document, but on the other hand, I mean, there is this demand for more transparency. And it's important to know that among diplomats, there is an expectation that that diplomacy should be treated as secret, or at least many aspects of diplomacy should be treated in secret. There are many experts in the diplomatic science, if we could call like this, that say that diplomacy and secrecy is they are two concepts that are intermingled. Because, for example, when you are in a difficult and quite complicated negotiation, I mean, going into the public, for example, showing the details of this negotiation can be quite detrimental to interests of the society. So there is an expectation among diplomats that diplomacy should remain in secret, or at least, there are some values that are brought with diplomatic interests that they should be kept secret. And But not only there is this expectation among different diplomats from different countries, but also among diplomats of single countries. For example, the Vienna Convention on Diplomatic Relations mentions explicitly not only the idea that the idea of secrecy should be kept as an important value in the interpretation of the Vienna Convention, but also that the communication between the capitals and also the diplomatic missions, they should be kept confidential. And I would like here to bring to you one of the main functions of the diplomatic diplomatic law. As maybe many of you know, that the Vienna Convention on Diplomatic Relations is structured on the basis of functions, which are in the Article 3 of the Vienna Convention on Diplomatic Relations. I mean, the idea of function is absolutely essential to interpret the whole Vienna Convention. And one of those functions, there are 4 or 5, depends on the reading, but 4 or 5 main functions that are described in this Article 3, and one of them is ascertaining by all lawful means conditions and developments in the receiving state, and reporting thereon to the government of the sending state. This is Article 3D of the Vienna Convention on Diplomatic Relations. Well, the idea of reporting to the government of the sending state is something absolutely essential to diplomatic law. And that reporting sometimes should be kept in secret. Otherwise, important interests of the state can be at stake if this secrecy is not kept. Well, but let's now go into the very specific provisions of the Vienna Convention on Diplomatic Relations that treat this idea of secrecy of documents. And I would like to read them because they are quite short, and I would like just to focus on 2 of them. Of course, there are some others that we could also bring here, but I would like to focus on those, which is Article 24 and Article 27.2 of the Vienna Convention on Diplomatic Relations. Article 24 is an article that deals with the inviolability of the archives and documents of the diplomatic mission. And it states, the archives and documents of the mission shall be inviolable at any time and wherever they may be. So it's important here to emphasize the final part of this article. Inviolable at any time and wherever they may be. This can be shocking for taking into account a modern worldview, because there is no limit in terms of time for this inviolability. For example, if you look into many domestic statutes, or in Brazil in my case, but certainly here in the UK as well, there is a time limit for any document to remain confidential, for example. But the Vienna Convention on Diplomatic Relations doesn't establish any time limit. And also, wherever they may be. This is also very important because, as many authors mention, and even the UK Supreme Court said that in a quite famous case I will mention at the very end of my presentation here, the Bancoult 3 case. The UK Supreme Court said that this expression, wherever they may be, entails an obligation erga omnes partes, which is something quite important right now in many discussions on, for example, climate change. You know that the recent advisory opinion of the ICJ established that many provisions of the Paris Agreement, for example, they are obligations erga omnes partes, in the sense that every single part of a treaty is interested in respecting that provision. So theoretically, if this argument, could be advanced before, for example, the International Court of Justice, it was never advanced before the ICJ. But in any case, maybe the ICJ will say the same as the UK Supreme Court said, that any state which is a party to the Vienna Convention on Diplomatic Relations has an interest in keeping, for example, the secrecy of a diplomatic document because of this expression, wherever they may be. There is also another article which is important now, and I would like to focus on them, which is Article 27.2, that deals with the official correspondence of the diplomatic mission. And it states, the official correspondence of the mission shall be inviolable. Official correspondence means all correspondence relating to the mission and its functions. Do you remember I just mentioned how the idea of functions in diplomatic law is important. It's quoted explicitly here, relating to the mission and its functions. So this is what characterizes a correspondence as official, a relationship with the functions of the diplomatic mission. I brought those two provisions, one that deals with the document itself and the other one with the official correspondence, because not only in doctrine, but also in jurisprudence of international tribunals, the document, the diplomatic document, is treated the same way as the official correspondence. Why? Because the official correspondence is, for different purposes, a diplomatic document in transit. And the diplomatic document itself is in situ, which is, normally it is on an archive, for example, of a diplomatic mission. But so there isn't properly a difference of nature between an official correspondence and a diplomatic document. The difference is in terms of the aim, because when you characterize a document as an official correspondence, the idea is that it is in transit. So, there is the Vienna Convention on Diplomatic Relations contains no definition of either the diplomatic document or the diplomatic correspondence. But state practice and also doctrine is absolutely consensual in the sense that they can take many forms. And this is an important aspect taking into account what we are discussing right here, because nowadays the electronic format is the most widely used format for diplomatic documents and, of course, for official correspondence. And as a result of that, cases of violation of the inviolability of diplomatic documents and correspondence have grown exponentially in recent times. There are many reports of, for example, leaking, interception, or unauthorized downloading or unauthorized copying of diplomatic documents. Sometimes it's relatively easy to intercept those documents. You know, many of you here are young students, but perhaps you have heard about the quite famous scandal of the WikiLeaks, maybe 10 years ago. But it was a big scandal that put into peril the basic tenets of diplomatic law. There were many discussions, not only bilaterally among states, some that intercepted information, diplomatic information, and some that were victims of that, but also at the multilateral level. For example, there is a biannual resolution of the UN General Assembly on on enhancing the protection of diplomatic personnel and also diplomatic missions. And there, at this biannual resolution, it was reestablished the importance of the inviolability of the document. So states are quite concerned about that. Even states that violate that provision, because of course they can be victims of that as well. Diplomatic law is a fascinating field because, of course, there are disparities in terms of powers, but reciprocity plays a crucial role. So even I mean, the most powerful states, they are quite concerned about the possibility of being victims of this kind of activity when they are abroad. I mean, when they have missions abroad. Well, just to say some words about the interpretation of the content of both rules I just mentioned to you. The International Court of Justice and also the Eritrea-Ethiopia Claims Commission both interpreted the content of Article 24, and this is easily applicable also to Article 27(2) that deals with official correspondence. 24 deals with the diplomatic document. And both the ICJ and the Eritrea-Ethiopian Claims Commission said that the protection of diplomatic documents is an unqualified one. So there are no exceptions to that. And in one of the cases in which the ICJ said that, it is one of the most dramatic cases dealing with diplomatic law, which is the Tehran hostages case, because not only students in Tehran, they kept diplomats and consular authorities as hostages, but also they confiscated some diplomatic documents from the American embassy in Tehran. And the ICJ said in a quite explicit way that this protection is an unqualified one, and Article 24 entails two duties for the receiving state. And this is quite important in terms of legal interpretation of that rule. First, there is a duty of abstention, and another one is a duty of protection. So every single state, and we could also claim that this is applicable to all states that are parties to the Vienna Convention on Diplomatic Relations, that they have a duty to abstain in the sense that not violating the document, but also protecting it. This duty of protection is clearly due diligence duty, in terms of this is an obligation of means, not of result. And you know very well that the due diligence duty now is being discussed and in many different fora. By the way, the International Law Commission included in its long-term program this topic, due diligence. It is not included in the IOC agenda yet, but it's in the long-term program, and possibly in some years the IOC will deal with this. But of course, in terms of climate change litigation, this is a quite important concept. So in diplomatic law also, this duty of protection is a due diligence one. So the state has to fulfill, a function in terms of providing all means possible to protect that that document is not violated by any private person or entity. So, I just would like to finish, because I think I have just 4 minutes remaining. I would like to give a final note on a quite concrete case to show how this tension between the growing demands for transparency, but at the same time, the retention of this important, those important provisions of the Vienna Convention on Diplomatic Relations, the tension between those two values. Because, as I said, in terms of international jurisprudence, it's quite clear how documents should be protected, and this protection is a quite strong one. But I would like to give a final note on a concrete case, which is the Buncle 3 case, a case judged by the UK Supreme Court in 2018. By the way, it's a quite important case. I recommend you to read because although it deals with a quite technical issue, but it's important to reflect on those values that are behind those ideas of transparency, those ideas of the functioning of a diplomatic mission. Just to give you a very brief idea of the case, the case Buncle 3 involved the use of diplomatic cable in judicial proceedings, reporting a dialogue between an American and a British official regarding the situation in Chagos. And such a cable, it was made public by WikiLeaks. So the idea was basically using that document that was in WikiLeaks in judicial proceeding. I won't go deep into the details of the case. By the way, the details of the case are quite complicated because it involves, in this cable, there were quite racist phrases that were reported. But I will not go deep into this. It's a sad story. If you read this cable, it's a sad story. But what interests us is how the UK Supreme Court dealt with the issue. Because if the diplomatic document is inviolable, it cannot be used in judicial proceedings, unless, of course, the state concerned authorizes that. And that was not the case, because the British government, neither the British government nor the US government authorized the use of that document in judicial proceedings. So this is a quite important case, and I think it reflects very well this tension, because there are many interesting points about the importance of the protection of the diplomatic document. For example, as I told you, the UK Supreme Court said explicitly that Article 24 entails an obligation erga omnes partes. With all possible words, the UK Supreme Court said that. Something that, for example, the ICJ never said. And also, the UK Supreme Court emphasized the idea of those two duties, that there is not only a duty of abstention, but also of protection. And that was quite important because in the previous jurisprudence of the House of Lords, there were some doubts about that. There were some cases in which the House of Lords said that there was only one duty, the duty of abstention, but not of protection. So in this case, this is a quite important case because it emphasized that there are two duties. But on the other hand, the court allowed the use of the diplomatic cable in that judicial proceeding. Although unfortunately, at the very end, it didn't serve the purpose of what the people that were interested in using that diplomatic cable in judicial proceeding they wanted. But I don't want to go into the details of the case. But in any case, the court allowed the use of the diplomatic cable in judicial proceeding, arguing that the diplomatic authorities did not retain control of the document, since the cable contained no indication that it should be kept confidential. And this is a bit problematic because, as I told you, the jurisprudence of the ICJ and arbitral tribunals say that the protection of the diplomatic document is unqualified. And when you put that, when you require that there is an indication, which is sometimes sometimes you get this indication when we receive some emails. There is something that people put, this is a confidential email, you need authorization to use it, to forward it. This is basically what the UK Supreme Court said. But the problem is that in the Vienna Convention of Diplomatic Relations and in the jurisprudence of international tribunals, there isn't such a qualification. So at the same time, the case is quite important because it reinforces the protection, but at the same time, it says, no, because the document was public, and at the same time, because there was no indication in that regard that it should be kept confidential, so it can be used in judicial proceedings. Moreover, this decision of the UK Supreme Court in terms of allowing the possibility of using in judicial proceedings documents that were leaked by WikiLeaks contravenes the jurisprudence of other tribunals, such as, for example, the Special Tribunal for Lebanon has a case in which it said that WikiLeaks documents could not be allowed as judicial evidence. And also the Spanish Higher Court of Justice said the same, that WikiLeaks documents were rejected as evidence in judicial proceedings. Just to finish, these are just some, this is just a sample of how tensions between rising demands for transparency and well-established rules of international law governing diplomatic documents and official correspondence need to be better managed in the future. We live in a transition between, those values that are pressuring us, the value of retaining the importance of the diplomatic law rules, but at the same time, those increasing demands on transparency. Thank you so much.
Thank you, George. Last but not least, Nehal, the floor is yours.
Thank you. So I'm just going to stand up because I have find it easier to explain myself. So thank you to Emma and Stina for inviting me to address this question. The first thing I'd like to draw your attention to is the wonderful picture that accompanies the question. This is a question. This is a picture of a statue without a head and a statue without a head or arms. The statue which has arms holds a book. The statue without the arms, I think, holds nothing at all. So I think it's a poignant symbol about how we might wish to both pose the question and answer it. Right? It carries with it the idea that perhaps one way of characterizing our present crisis is that we live in a world that has lost its head in multiple ways, and we live in a world that has lost its limbs in some way. That part of the world that has lost its head has its limbs but holds a book. But of course, a body without a head cannot read. So I think it evokes, and I don't know who chose this picture. Is it you, Steve?
I saw it in a museum in Buenos Aires. It's an unauthorized use. Yes.
It's captured on tape now.
Yeah, but I mean, who's gonna watch? Aside from international lawyers.
You've committed the crime of copyright violation.
Yeah, transnational. Yeah.
But in many ways, it captures also the perplexity of our present. So I suppose perhaps in contrast to my colleagues, I'm going to move from some fairly up, I suppose, from the level of some somewhat detailed questions to try to think about how we answer this question. Who governs the world? Who governs when the world is falling apart? I have, broadly speaking, 4 observations to make, which hopefully will help us clarify what it means to pose the question and thereby allow us maybe to identify some possible answers. But a good place to start, I think, for all of us is to first ask, who governed the world when it wasn't falling apart? And of course, it remains open to us to ask the question, exactly when did the world fall apart? Or when did it start to fall apart? Was it 1989, 2001, 2003? Was it 2025? All of these, for those of us who've lived through these periods, brought with them forms of crisis, forms of occurrence that seemed once again to raise the specter of some kind of change or collapse or diminishment of international law. So, of course, it's become now, in some ways, increasingly easy, if not fashionable, to speak of the death of international law or the risk of the death of an international legal order. I think, as George has just shown us, from within the bureaus of embassies dealing with their diplomatic correspondence, this is a death which is greatly exaggerated. Right? The day-to-day mundane functioning of the international legal order will continue. And in that sense, it will be maintained and reproduced and governed, even as the world falls apart, by people educated similar to you, international lawyers who share a common modality of thinking about the interpretation of a treaty or engaging in argumentation based on cases or materials. Right? So those who are in some sense socialized and accustomed to the modes of arguing that create an order out of a set of rules. And sometimes that order can be extremely durable. It's an order that is pedestrian in lots of ways, but it will continue to function even as the world falls apart, and has actually historically in the last 200 years, in other times when the world has fallen apart, 1815, well, actually 1789, 1815, 1914, 1945. In all of these times, what we would think of as the ordinary functions of, let's call it a legal habitus or a legal expertise, making meaning out of a set of texts that's in front of you in order to make an argument as to why this is or is not a violation of the diplomatic practice, that will continue. Right? But at the same time, it's clear that will not stop the world from falling apart in some basic sense. I think we will continue necessarily through our emissaries and through our representatives, we will continue to have the necessity of those kinds of legal practices and legal operations. We can't live without them in some sense. But at the same time, the world will continue to fall apart, or could well continue to fall apart around us. And so that begs the question, when we speak of the imminent death of international law, what are we actually talking about? It's not really the death of the diplomatic bag. I doubt very much. I don't think it's the death of Article 31.3.1 of the Vienna Convention or Article 38.1 of the International Court of Justice. That will continue, and yet the world will fall apart. So what does that mean, and what could it possibly mean? I think this way of observing points to these two different registers of the idea of international law, two different historical registers. It's the function of the idea of international law or as a set of practices and also as a theory. And as the great, well, it's hard to know how to understand it. The great man of letters of the French Revolution, Abbé Sieyès, who wrote that wonderful tract, What is the Third Estate, said, he said that the practices of a period are nothing but an expression of its theories. So these two theories of international law, it's apparent quotidian normality in ordinary interaction, which will continue. But at the same time, the sense in which, despite its quotidian normality, it's unable to sustain itself in the face of grand shifts in relationships of power and arrangements between states. And we somehow ask international law to do both of those things, to maintain the sanctity of diplomatic correspondence and the immunity of diplomats, but also to create a framework for peace and security. Those two things are not radically different, or they're not completely dissociated, but they operate at different levels. So the first observation I suppose I wanted to make is just for us to begin, before we can really even begin to start to answer this question, we must at least distinguish these two faces of international law. The first face is historically a form of statecraft. The idea of a sovereign state, the idea of a unified public power that governs exclusively over a territory and a population, right? We can think of this in terms of Article 1 of the Montevideo Convention, but the idea of stateness itself is a product of what in the 16th century was understood as the jus gentium and the jus natural. So the state is a product of an architecture of theory called natural law and the law of nations. It emerges as a set of argumentation, not completely different from the kinds of arguments we might have over diplomatic immunity today, about what is the nature of public power, who's authorized to govern, and what is the purpose for which they should govern. Right? And the answer to that was that ultimately what should govern is not an empire, or in fact an empire cannot govern, okay, as was concluded in the 16th century in the context of Europe and the collapse of the effective power of both Holy Roman Empire and the papacy. What should govern is what theorists from Baudin through Grotius to Hobbes and ultimately Vattel concluded was a societas perfectas, which was a sovereign public power answerable to no other higher authority. So that is a product of what is, I think, one of the fundamental registers of what we think of as international law, or its predecessor, or its antecedent, jus gentium, jus natural. So in a previous time in which the world was falling apart, at least in Western Europe, a time at which can best be characterized as a sectarian civil war between Christians, between Protestants and Catholics. At the time of this sectarian civil war, which raged from more or less 1520 through to 1648, the question of who governs when the world was falling apart was a question of which form of political association has the right to rule. Is it the church? Is it the heretics, the Protestants? Or is it the empire, which by that stage was really just the house of the Hohenstaufen? And the answer given by international law, and the means by which this new reality was created, was the state. That the state, the societas perfectas, answerable to no higher power, had the authority, including the authority to use violence, to control its territory, but to what end? That end too was set by the jus gentium and the jus natural. That end was not Christian salvation, because if you made the purposes of Christian salvation the ends of the state, you were back where you started, in a sectarian civil war between Christians who had different conceptions of how to be saved, the Protestant versus the Catholic, and within the Protestants themselves. So there could really be only one purpose consecrated by international law of the state, which was understood as consistent with the requirements of what God intended for human beings, which was the flourishing of the population, its material well-being. Civil peace was the purpose of the state, and the purpose of civil peace was to enable people to flourish without fear of untimely, violent death at the hands of their neighbors, but also with the possibility, and this was critical, that their flourishing may grow through the civilizing possibility of commerce between states. So this is one fundamental register of international law. It's a register that emerged in answer to the question, who governs when the world is falling apart? And the answer it gave was to pose what was at the time a new, in some ways radically new idea of political society that would be consecrated by the jus gentium and the jus natural, and once consecrated would also be empowered to maintain its existence, including by violence. So an important footnote here is that the distinction that we've often maintained, and it's a distinction which comes back frequently these days, between the idea of the reason of state and international law, or the reason of state and the jus gentium, is not a viable distinction. Reason of state was the purpose of the state consecrated by natural law. This is true not just in Baudin and in Hobbes, but also in Grotius, also in Pufendorf, also in Vattel. So international law gave us reason of state as a way of capturing the idea of what the state should be for. The state should exist in order to enhance the welfare of its population, which includes, of course, the right to go to war. So the question of who governs when the world is falling apart is partly a question, necessarily, of what is the purpose of our political association and what means do we have in order to maintain those purposes. That's one register. But the second register of the idea, or the second historical register of international law, brings us back to the more quotidian functioning of the rules governing, in a legalistic way, the relationship between states. So jus gentium, jus natural was always a kind of philosophy, a political theory of the nature of political community, the purposes it served, and the nature of its substance. But simultaneously, as Hobbes famously taught us, but not only him, the state was, the Leviathan, was an artificial person. To be an artificial person in that sense was not to be a fabrication or a fiction. To be an artificial person was to be a person capable of action through the artifice of human construction. The artifice of human construction that creates the state is law. So even Baudin, our very famous theorist of absolute sovereignty, said, well, what is really sovereign power? Sovereign power is not the unrestrained ability to enforce one's will. That's despotism. That's characteristic of the relationship between a property owner and a slave. But sovereignty is not the same as the ownership of a slave. So in Baudin's analogy, or Baudin's argument, sovereignty was not the power to enforce, it was the right to command. The right to command could only be articulated through a legal architecture, subject then to lawyering, to juristic construction, to interpretation. What is the source of this authority? What is its foundation in legal terms? What does it mean to exercise it in accordance with juristic constructions? So at its outset, Right? On the one hand, operating at the level of kind of political theory, of political philosophy, it simultaneously created or articulated the idea of stateness, statehood, as fundamentally a juridical construction. Right? Juridified in its relationship to other states, but more importantly, juridical in its relationship to how it governs its own population. So all states in that sense are artificial, as Hobbes understood. They're artificers, products of human will and understanding to construct stable relationships by which humans interact with each other so as not to kill each other because of their consistent tendency to delusion and to misunderstanding, but also to relate between political entities. So these two faces, let's just, for the sake of brevity and simplicity, let us call them the statecraft face of international law and the sort of the juridical state of international law. So these two faces are, in a way, always at play in the context of any crisis in the international order. It's the tension between these two dimensions of international law. International law is neither exclusively one nor the other. Not just as a system of rules, you cannot have a legal order without a system of legal rules, but you cannot reduce a legal order to a system of legal rules, as Carl Schmitt certainly taught us. So the orderliness of a legal order is the product of conformity of behavior, but the orderliness of a legal order is also the product of a certain framework of commonality between its subjects, such that they can be expected to function in relatively similar ways, right? Including in the ways in which they engage in conflict with each other. So in any crisis of the international order, these two dimensions. So I guess what I'm really driving at here is when we try to answer this question, who governs when the world's falling apart, we should not be asking that question as though it's some kind of radical contrast between law and power, as though it's some kind of radical contrast between law and politics, between some kind of radical contrast between reason of state, transactional bargaining, and the niceties of legal rules. Okay? These are both dimensions of the legal order. These are both strata of the way in which law, international law, these two faces of international law have constructed and maintained or helped reproduce the legal order. I think the mistake, overwhelming mistake of many international lawyers is to focus only on the second part, the system of rules and their interpretation and their juristic construction. But those system of rules are merely words in the absence of the dimension of orderliness that is also maintained through the functioning of the legal order. And the orderliness is not maintained by the rules themselves. So in the context of international law, the tension between, let's call it the order embracing or the order reflecting function and the juristic rule dimension, that tension becomes most visible, most obvious during periods of apparent crisis. And so my second point is then, how do we think about crisis? What is a crisis? And here I would refer to the work of the intellectual historian Istvan Hont, the late Istvan Hont, where he says that in the history of thought, crisis has several idioms. One idiom of crisis effectively substituted for a religious idea. He calls it the religious eschatological end state. In other words, crisis means the end of days. It starts out fundamentally as a theological idea. Once you enter the crisis, then the new world is coming. This is a eschatological Christian concept. So crisis signifies an endpoint and a rebirth, and so which can be secularized in the form of some kind of collapse followed by utopia. So all of us who've read the Communist Manifesto, and if you haven't read the Communist Manifesto, you should. This is fundamentally a secularized conception of an eschatological idea of crisis. Death followed by rebirth. That's one version of crisis. But his point is that that a less stark interpretation of the concept of crisis is the medical concept. And he points out actually that the word crisis enters the language not in its religious meaning, but rather simply implies a moment of decision, a turning point, when the road to recovery had to be opened if some kind of irrecoverable descent was to be avoided. So a crisis was the moment between a possibility of a return to health or some kind of decay, which was terminal. That's different from the eschatological idea, sudden death and rebirth. So he says, in that sort of crisis, the patient stumbles from one relapse to the next, where the crisis is always recurring but constantly changing in its precise nature and location. This seems to me to be the form of crisis that best fits the international order. Which crisis? Well, there's the dramatic crises of 1914 and 1945. But between 1945 and now, there's also been many crises, which fit, I think, the second term, a kind of stumbling, where it enters into a period of in-betweenness between one thing and the next, without death, but without full health. Right? So think Korean War, Vietnam War, invasion of Afghanistan, the collapse of the Bretton Woods system, 1989, 2001, etc., etc. So my second point is when we're thinking of, what are the contexts in which we have the perception that the world is falling apart? Well, we are thinking of a crisis, but it seems to me, and I think this is certainly true of the present, it's less likely that we should analogize this to a crisis of this eschatological kind, where complete destruction is replaced by utopia, or complete destruction is replaced by some kind of permanent dissolution. It's more actually a kind of in-betweenness. And I think that's certainly true of the present, an interregnum. So Pufendorf, the 17th century philosopher, lawyer, historian, who held the first chair of the law of nature and the law of nations in Europe, which was established in Heidelberg, wrote that during an interregnum, the people do not immediately disintegrate and fall back into a state of nature, but default instead into their pact to form a society. So in other words, they default to some prior set of concepts and arrangements that they sort of were working with already. A slightly more pessimistic version of an interregnum was given by Gramsci, although not, I think, completely divorced from Pufendorf, where Gramsci said, some of you may be familiar with this, it's become a bit of a cliche recently, the interregnum is the moment in which the old order is dying, but the new one is not yet born. It's the time of monsters. Now, Pufendorf, he also used the concept of monstrosity, actually, to describe political forms that emerged during the interregnum. Monstrosity for Pufendorf was not a kind of, it's not a character in a horror film. Right? A monstrosity for Pufendorf, and I think also potentially for Gramsci, is a use of forms that don't really fit together. Right? It is a Frankensteinian idea. Right? So if we were able to regraft a head onto this decapitated statue, but not a head from the time, not the head that belongs to the statue, but a head from a different time, that's a monstrosity, at some level. So interregna, in this understanding, in this second meaning of crisis, are periods in which there is entropy, there is decay, in which legal concepts no longer serve the order-maintaining function that they used to serve, even as the quotidian work of legalism goes on some issues, but in which we are grasping for new kinds of arrangements, and those arrangements are not derived from some kind of rational analysis. They are, in that sense, monstrosities. They are things that we cobble together from what's lying around us. So it seems to me that, I have a lot more to say about what is the nature of the legal order that we're leaving behind. Right? We talk about the rules-based order, and so when we talk about the crisis of international law and the indifference to the genocide in Gaza as a symptom of that crisis, well, the indifference to the genocide in Gaza is certainly a crisis, is certainly a symptom of a certain kind of crisis, but I'd say it's a symptom of the second crisis, not the first. It doesn't portend the death of international law. It portends this interregnum. And the nature of the interregnum, the question of what we have left behind, I think also has to be carefully evaluated on its own terms. We can't be naive, and I think we cannot misunderstand the history of the legal order up to the present and what was the foundation of its apparent successes. To put it in a slightly compact way, in a brief way, because of the shortage of time, you might say that the appearance of, or our preoccupation with the international rule of law and our valorization of that idea has overwhelmingly focused on the second phase of international law, its legalistic, rule-based dimensions. But in the context of the post-war order, this was intimately connected to a kind of managerialism, which in some ways sought to reduce or diminish or ultimately make completely disappear the second dimension of international law that I have referred to, the statecraft dimension. But ultimately, I think, unsuccessfully. So the demand of maintaining a particular attitude towards the existence of positive rules is well and good, but at some point the conditions that underpinned the possibility of that attitude have disappeared. And my observation would be, we can't really say, we can't return it, we can't look to it by insisting that despite the fact that this person is headless, the book she holds still governs us. A headless person, a headless agent is not arguably an agent. They are encephalous. An encephalous order was, in the Greek understanding, always an extremely dangerous one. So, there are a range of other things that can be observed here, and I won't develop them further. But I guess the question I want to pose, or the way of putting the question of who governs when the world is falling apart, in an essay in the late 1950s, early 1960s, the philosopher Michael Oakeshott gave a little talk on BBC Radio about the Leviathan, about Hobbes' great work, The Leviathan. And in the context of that talk, Oakeshott said, one way of understanding the idea of the rule of law is that it's a kind of collective dream. And the question for the philosopher, and in my view also the question for all of us if we're thinking about the international rule of law, is to what extent is it, or should we be seeking to deepen our dream, or to what extent should we be trying to awake ourselves from this dream, particularly if when we awake, we find that having roused ourselves from our dream, we have awoken into a nightmare. Thank you.
Well, I want to thank our three speakers for delivering exactly what we had hoped for, which is a diverse and profound set of reflections to help us navigate and reflect upon the present moment. We went a bit overboard with time. I think it was worth it. Do you think it's fine if we do a 10-minute Q&A? I'm looking approval of Emma, I've got it. And then proceed to the wine reception. So the floor is now open for questions. If you're posting a question and you would like to introduce yourself before, that would be great. Yeah, Danny over here. Okay, great, thanks. But it's for the purposes of the video, so yeah, thank you.
Hello. Thank you so much. Can you hear this? Hello. Is this okay? Okay. Thank you so much. I'm Danny Reeder. I am an affiliate of MILC, although I finished my PhD at Liverpool. And so I have a question for the entire panel, but I will segment it to each panelist. Megan, you talked about the historical narrative of this governance structure, especially alliance and these things. And if we remember this form of alliance structure, the statecraft, you have states intermarrying, aristocracy, you have to be from noble birth. And this is a question of who states are, and they are almost divine in that sense. And the rest of us are just kind of mortals. This falls out of practice. And in the modern era of this narrative, states are supposed to be mortals too. But what we kind of see now, especially in the US, and especially with this sort of, I'm not going to put a name to it, but this likening of Trump or something to God, this disempowerment of people once again. They are not mortals, they are these sort of subjects underneath everyone else. And so to finish, with the social media, does this also have a play into that disempowerment of people? And then if I direct to George, this idea of protection of people. So the secrecy that we have, it's for protection, but how do we measure that protection? And if we're not protecting, what are the consequences? And then finally, for Nehal, this question of what are we leaving behind in this stage of death? And there could be good or bad. And the good, stability, but the bad, I often think of these racist and constructions of the civilized and the savage. And so what are some of your thoughts on that? Thank you.
Thank you, Alejandro del Valle. I am visiting researcher in the MILC. Thank you. I would like to put a question to all the panel. And during some period of time, year or months, everybody was thinking that the world order was going to be scrapped. And it was the old order, and now we have a new order. I agree with you that the main structures, core structures of international law are existing there. They are alive. And but I would like to ask you which are the main fails in this continuing living world 85, 40, 45 legal order, which are the structures still living. You are talking about the diplomatic relations. It's clear that customary international law is still going on. But which other continues? The use of force, of course, is clearly under critics and is not more available, the United Nations system, but the Security Council resolution are still valid, and the big powers use them for legitimate some deals. So the United Nations is still there. What do you think about the main failing points of this old order that do not survive anymore?
So I basically had a question on something that Dr. Donaldson mentioned. I might be paraphrasing a bit, but you said that appeals to transparency can come across as efforts towards a neoliberal governance. In the current geopolitical scenario, we see that there has been a shift towards the political right. And does that then imply that we are going to potentially see a world where this demand for transparency gets squashed? And adding on to that, Professor George, you mentioned that diplomacy should, to a certain extent, remain in secrecy. But adding on to that narrative, to what extent should that secrecy be? Thank you.
So let me do a real lightning round of very quick interventions on each of these enormous questions. Danny, can I just pull out of your question what I think is a really interesting contrast between an intense focus that we see now on personal power. So as you mentioned, this kind of personal executive power incarnated by Trump, and this question of acephalousness, right, the missing head. The two sort of go together. Intense personation of power means that you lose the system building function of law. It's harder to maintain that. But I do think that there's some deeper question here for law and its connection to agency, right? So law can't work without some sort of idea of human agency and reasoning entities. It really has difficulty coping with complete arbitrariness. And it's also sort of conflicted a little bit on the other side in this relationship with technology. So I anticipated Nehal was going to talk about algorithmic governance, which is why I mentioned algorithmic governance, but that's a little bit what I have in mind. It removes the sense of social and individual agency on which law depends. So there's a tension there. For Alejandro's question of what still lives, I think we don't know. But a question which emerges actually from all of the interventions here and from Nehal's useful distinction between international law as quotidian rules and international law as underlying order is actually what are the internal systemic dimensions of international law? If you leave one rule behind, particularly a symbolic important rule like rules on use of force, what happens to the other rules? Do the secondary rules still apply, right? Do they still maintain? I think law is a really complicated fabric of things, and when you pull out one thread, you can anticipate that it's going to relax other areas, but you don't quite know until you watch it. So in a horrible way, we're living inside this experiment. And on the third question, I apologize, I didn't catch your name, but I think you draw out something which I touched on really, really quickly. It's that sense that transparency is part of a very neoliberal vocabulary and doesn't provide much resistance, right, to the kind of deformalized neoliberal and not particularly emancipatory forms of governance. And what do we do about that? And I think you don't concede. That's the sort of argument I'm gesturing at the end. I think there was a very dominant critical move in the last 10 or 15 years to really lean into an idea that transparency is either completely submerged in neoliberalism or it's underwriting these very dangerous, insidious technological forms of surveillance of everyone. And I don't think that it is. I think that longer vision shows you that there's a transparency politics under all kinds of other names in different places with different techniques, used creatively and imaginatively by different kinds of people, and that is going to have to be part of a future. We don't know what it looks like yet.
Well, thank you. I'll try just to grasp some ideas. I don't know if I will answer all the questions, but if I don't answer, please you can pose another question. I mean, the first question is who is being protected. Let me just go to the basics of my argument, and in that relation, maybe establishing some link from what was said here. But the idea, for example, of the protection of the diplomatic document is something that is important, but I think it implies many things at the same time. And I don't think this is something that must be written in stone, and we should simply, not take into account what is going on in terms of many values, especially in domestic law. For example, when the Vienna Convention on Diplomatic Relations states that, diplomatic document must be protected in any circumstances, it doesn't say much, for example, about how you do this. What are the means for you to do this? Because I think there are many developments, for example, in domestic law, but taking into account so many different values. For example, you should give a proper reasoning for that in domestic law, for example, to protect a diplomatic document. This is not something that should be justified on its own terms. It's not because, only the rule establishes that you should protect. Of course, there is some fundamentals, and you should give a proper reasoning for that. For example, I know that in the U.S., the United States has a very strong legislation, which is, at least from my point of view, it's even more wide than what diplomatic law provides, because, for example, there is the possibility of classifying some documents, and you don't have any perspective in terms of making them public, for example. But there are many interesting arguments right now that, for example, you should give a proper reasoning for that. And I think this is something that we should explore. And by exploring this, we are also providing many values that are on the underpinnings of our modern societies, to justify why a document should be protected. And this would be just something it's important to stress here. I just would like to say another word on the idea of this changing of order. I have a normally, maybe it's a fault of mine, but I have always a historical perspective on different issues. And I think that this movement of change we are going on right now, it's quite complicated because it brings us some discomfort, because, of course, we are quite acquainted with the structures as they are right now. But I think it opens many possibilities as well. And I think we should see phenomenon through lenses and establishing possibilities, for example, of inverting hierarchies. And when the world is falling apart, is also the possibility for us to invert those hierarchies. Of course, I come from a place, Latin America, and I should stress, my origins here, that of course we suffered a lot, from many perspectives and from many different superpowers throughout history. And I think there are many paths here to invert those hierarchies. Of course, we should focus on specific topics in order to make this a reality. I don't believe in a complete change of order in all respects, but maybe there is a possibility for changing the order on some specific themes. For example, I see many good prospects on what relates, for example, the idea of climate change right now. I think we are living a good moment about that. Of course, in terms of use of force, we live a disaster, a complete disaster. But there are some prospects for that. So I'd just like to say a word on this, and of course, on what relates to diplomatic law. It's important also to reassess all those bases, to rethink about if they are useful or not. if they are describing or being responsive somehow to important values that we share right now. And it's important to pose these questions. I love a sentence by the Spanish philosopher Ortega y Gasset, who says that arguing means starting to understand. I mean, you start to understand when you pose questions. And I think when we pose questions about the international order right now, I think we are doing the right way. That's yeah.
Thank you. So I guess I wanted to make two observations. One is the question of what we've lost, and the second relates to how do we diagnose, how do we evaluate the prospects for certain kinds of multilateral institutions today, such as the Security Council. And I think this will connect with what George has said. So the question of what we have lost, I think, as I intimated in my remarks, I couldn't really unpack this idea, but I think we need to see it in a historical perspective. There's far too much romanticization of the notion that 1945 inaugurated a kind of international rule of law. It inaugurated, or let's say refounded, a series of universal structures which were, I think it's important to choose our words carefully here, I think which were understood by the dominant power of the time, the United States, as being fundamentally strategically in their interest, but not always tactically. Right? So I think the distinction between strategy and tactics is important here. And I think this is what's changed. Right? So at some basic level, the United States had accepted that the 1945 framework was going to be the basis for through a vector through which power could be channeled, and a means by which order could be maintained. And it proved to be, at some level, quite successful. For example, the process of decolonization from a legal perspective was effectively channeled through the universal institutions. I mean, that didn't stop it didn't stop colonial powers from waging wars in their attempt to maintain their colonies, but ultimately the universal institutions played the critical role in transforming what was ultimately a social political force from within territories into a new international arrangement. Right? So and what was the position of the United States in all of that? They were constantly worried that these movements would become communist allies, and in some instances they sought to stop them, so Vietnam being the clearest example. But in others, they simply concluded that there was no point in trying to stop them, and that they could be accommodated within this universal framework. So if you redescribe it in that way, what we see is a kind of commitment to the idea that this is the framework through which strategy should be pursued. And if you can't achieve what you want through it, then you go under it, you go around it, you go over it, but you don't break it. And I think that's the difference now. Right? And how we got to the position where the United States government reached the conclusion that this broad set of institutions, it's not just that they wanted to bypass them or get around them, which they've done many times in the last 80 years, but actually they wanted to break them. That's another important part of the story. And that has to do with the two faces of international law. An important secular trend after 1945, I think facilitated through the existence of these institutions, was an intensification of the managerial dimension of international law, right? What we would now call the rise of global governance institutions founded in treaties, which function as means of governing without governance through epistemic authority. And that's a secular trend. Right? So Michael Zern has done sort of some interesting empirical work on this. One of the critical observations about that architecture, and in many ways I think still the most important observation that was made in 1982 by John Ruggie, when he said, well, basically this entire framework, this approach to multilateral institutions as a managerial approach, right, embedded through the kind of language of international law, or the quotidian lawyering of lawyers in the institutions, lawyers in the bureaus, lawyers everywhere. The basic point was that they were to try to stabilize a relationship between states, but on an understanding that the state would constantly be intervening in its own economy in order to ensure a kind of social pact. So he pointed out in 1982, the biggest risk to this architecture comes not from too much state, but from the rise of a return to a liberal approach, which was going to break the foundations for the tolerance of this managerialism. Because at some basic level, international law, and especially the sort of the minutiae of international legal expertise, which unfolds through treaty interpretation, international courts, international organizations, is fundamentally undemocratic and non-democratic. Right? There's no way you can democratically legitimate it except in a very remote way. So if you want democracies to adhere to it, right, the critical thing you want to avoid is that it becomes a political problem for a democracy. Right? Brexit. Right? As soon as you make the European Union a political problem for a democracy, actually democracies don't sound so enthusiastic about them. So that's the underlying dynamic, right? That these forms of epistemic authority, which were the foundation for a kind of structure of governance that the United States helped build and promote, nonetheless rested on a kind of political economic understanding from 1945 to 1975, in which the assumption was states would function fundamentally as social states, if not democratic social states, but at least social states, right? Strong states. Once you start to untangle that, right, you're destroying the pact, as it were, right, in which government's construction of an interpublic order is accepted and tolerated. Right? Now, I agree with George. The current moment where you've actually got defection in the United States, possibility of defection here in the United Kingdom in 4 years' time, we don't know, right? It remains to be seen. Possibility of defection in some European states as well, right? That's an interesting moment for how you reorganize this. And here's where I sort of return to the present. I think what we saw in the Security Council yesterday or the day before was sort of a shameful example of the extent to which an organization, in order to try and protect the possibility of it having a function in international affairs, violates its own principles, violates basic rules of international law in order to preserve its relevance. That's a situation that has come about, in a sense, because of this wider picture where the very premise of the value of the institution is at stake, and it hangs by a thread, basically, at the moment. I mean, it's very interesting to contrast this with 2003. Couldn't get that resolution through the Security Council to invade Iraq. France said it was going to veto, and in the end, they didn't get the votes. Right? Very different from what we see yesterday. And the shadow that's being cast is the shadow of the history of an excessive dependence upon one state as a kind of backstop, while at the same time, simultaneously, a kind of domestic political economic transformation is actually destroying the foundations of this. So, I mean, there's more to say here about, in particular, the excesses of the idea of the United States as the indispensable nation. In many ways, this is the high watermark this was the beginning of the end, in many ways, right? The moment in which the United States saw itself as the indispensable nation is also the moment in which, internally, the tenability of that kind of concept was less and less possible. So that paved the way in a certain way, right, for the abandonment of this notion that this was in the strategic interests in the long term. Right? So, so it is a moment of reordering. I agree. Some reorderings happen with moderate forms of violence. Some reorderings happen with extreme forms of violence. Very few reorderings happen with no violence at all.
Well, and with that, thank you to our speakers.